So we're going to move into the agenda for today's session. So again, you've selected the Youth Juvenile Justice System Juvenile Justice System panel. So you're going to come away with a deeper understanding of that system, including jurisdiction, sentencing, and collateral consequences. And for those of you who don't know what some or all of those terms mean, then you're in the right place because our experts will be able to share that with us. And you're going to also share insights on potential changes to the system and specifically debating a key question that exists within the criminal justice system world right now. And finally, you'll learn some resources on how to take action or how to learn more about this topic. So we just did the welcome and opening. We're about to move into the panel. I will introduce our panelists and they will go through the different pieces that are named here. Then there'll be time for Q&A and that will bring us to 10:30. At 10:30, you'll have a half-hour break. Then we'll come back here and we'll get a chance to discuss more and we'll do a mini debate activity on this question: should prisons exist for juveniles? And hopefully you'll be able to use some of the information learned in the morning as well as other background information you have to engage in that debate. So please feel free to put in the chat any questions you have about the agenda. Moving on, I think probably most of you, is anyone not familiar with Zoom? Can speak, like the Zoom functions? Okay, it seems like most people are, so I will move on from that. Just to share a couple of norms for this particular session. We'll ask that you stay on mute unless you're speaking when we're in this whole group. When we do breakout rooms, we invite everyone to unmute themselves so you can have a more free-flowing conversation. In the whole group, we'll stay on mute. Feel free to raise your hand if you have something you want to say, particularly when we get to the Q&A portion. But throughout the panelists speaking, please feel free to use the chat to share reactions, reflections, or questions you have. And then when we get to the Q&A, we'll have a chance to address those questions and you'll be able to unmute yourself and speak at that point. And this is just a norm at all of our events. Please use the chat to enhance and not distract from the conversation. And then again, later in the second half, we will be using breakout rooms. So we'll be doing that as well. And finally, we will offer grace to each other with technological bumps as they sometimes happen, as we are on a journey of learning together. With that, it is my pleasure and honor to introduce to you the three esteemed panelists and attorneys who are here with us to talk about the juvenile justice system. So first, I'd like to introduce you to Tinia Snow. Tinia is a civil rights attorney in the Office for Civil Rights for the U.S. Department of Education. She has dedicated her career to public service. Prior to joining OCR, Tinia was a trial attorney for over 8 years with the Youth Advocacy Division of the Committee for Public Counsel Services, where she represented indigent juvenile defendants in various delinquency and youthful offender matters. Her keen intellect and zealous advocacy were complemented and enhanced by her deep compassion and willingness to go that extra mile to help her clients and colleagues. Tinia's stellar work as a defense attorney were recognized by the Massachusetts Bar Association as a recipient of the 2019 Access to Justice Award. Tinia, a Boston native, received her JD from Northeastern University School of Law and graduated magna cum laude from Northeastern University with a BS in criminal justice. So welcome, Tinia. Please give a warm welcome, whether virtual or with your hands. Next, I'd like to introduce you to Migdalia Nalls. Migdalia was raised in the Roxbury and Dorchester area of Boston and is the first in her family to pursue higher education. She graduated from English High School and attended Boston College for both undergrad and law school. Migdalia is currently a trial attorney for the Youth Advocacy Division of the Committee for Public Counsel Services, defending young people charged with delinquent or criminal charges. She's previously worked as an attorney for the South Coastal Counties Legal Services Incorporated, representing low-income victims of domestic violence with family law cases and child custody and abuse cases. She was also an assistant district attorney for Suffolk County's Boston Juvenile Court. Migdalia has received multiple awards for her work, including the Brian J. Honan Award for Community Service and Courtroom Excellence, and with Mass Housing's Agent of Change Award. She is an active board member of the Massachusetts Association of Hispanic Attorneys and founded the annual Juvenile Justice Youth Symposium. Please give a warm welcome to Migdalia. And finally, our third panelist, Eliza Lockhart-Jenks. Eliza grew up in Southern Maine and came to Boston for law school, where she attended Northeastern University of Law. Eliza is currently a trial attorney for the Youth Advocacy Division of the Committee for Public Counsel Services. She practices in the Framingham, Cambridge, and Chelsea juvenile courts, representing youth who are charged with criminal offenses. She previously worked for the Public Defender Division in the Quincy District Court, representing adults charged with criminal offenses. So please, a warm welcome to Eliza. So thank you three. So at this point, I'm going to stop my screen, stop sharing so we can see each other, and I will pass it on to Tinia, who's going to lead us into the opening part of the panel.
Hi, everybody. It was nice to do the introductions first to know like who is here, and we have people here who work with young people in all different aspects, from the schools, nonprofits, the health arena, and even knowing that some attorneys are here. So that's very helpful. And hopefully you find this helpful today and informative. I'm gonna do my best to put as much in here for the overview for the juvenile court and within my 7 minutes. So first, let's start. I'm going to give you an overview. When you go on the juvenile court website, it says that the juvenile court's mission is to protect children from abuse and neglect, and to strengthen families, to rehabilitate juveniles, and to protect the public from delinquent and criminal behaviors. There's a number of different types of cases that come before the juvenile court. Today, we're going to focus on the criminal aspect, but just so you know, some cases that come before the court are the delinquency cases in which children between the ages of 12 and 18 are being accused of crimes. Child requiring assistance cases in which a young person is being told that they're not attending school or they're not following the rules of their home. There's also adoption cases, guardianship cases, also youthful offender cases. These are young people who are between the ages of 14 and 18 who are charged with a felony. There's also some other criteria that needs to occur before youth can be charged as a youthful offender, such as someone who has been previously committed to the Department of Youth Services, or who's been charged with a violation of a gun offense, or who has been charged with a crime, a felony, which includes an infliction of serious bodily harm. So there's a whole process before youth can be charged with a youthful offender case. There are a number of people who are working within the courthouse when it comes to a criminal case. You have the defense attorney, you have the assistant district attorney, you have the judge, you have probation. Everybody has a different role. Defense attorney, I worked, as you heard in my bio, as a defense attorney for over 8 years. I enjoyed it. And my role previously, and the person's role who's currently doing it, is to represent the voice of the child, of the youth that they're representing, to represent their interests, make requests of the court or motions of the court that will benefit the case, that will service the young person. The assistant district attorney, just briefly, their role is they represent the state. They are saying that someone in the state has been harmed and that the defendant has caused that harm. They don't represent the person who is saying that they've been harmed. They represent the interests of the state. The judge, their role is to be neutral. They're supposed to decide evidence. They're supposed to decide issues regarding the law. They make rulings on motions or requests that come before them. They make rulings on at what we call evidentiary hearings. They, well, I'm going to talk at some point, but if there's a trial, if it's a bench trial, they'll make a decision based on making a finding of fact, as well as what type of sentence that young person will receive. There's also probation in the courthouse. Probation is there to enforce conditions that are being set by the judge, and make sure that the young person is following those conditions. They also have a role of gathering information on families when they first enter the courthouse, when they do their intake, as far as like their background, what is their financial situation, can they afford to have an attorney? All of this, no young person engages with any of these people unless they go through a formal process with the court. So let's talk about how they get there. First, prior to coming to court, you have to be accused of a crime. And so an officer can choose to arrest a person who's being accused of crime, or they could summons them to come to court, or request that they come to court the next business day. If they're arrested, they're brought into court and they're being held at the jail, excuse me, not the jail, at the courthouse before they go before the judge. But let's talk about when you get to court. So you have, the first step is an arraignment. And in the juvenile court and in many counties, the court, a decision can be made whether or not the young person can be diverted, meaning they're not arraigned on a case, they're not formally charged, or they can make it a decision to arraign that young person and formally charge them with a crime. If they are arraigned, the judge can then set bail or choose to hold them without bail. If the judge sets bail, that is a dollar amount that a family is required to pay in order for that person to be released pending, while the case is pending. Each court date from the date of arraignment is leading up to that young person's right to have a trial. And so if bail is set, then if the person does not have the money to pay for bail, they will be held at the Department of Youth Services, which is a locked facility. If they're held without, it means just what I'm saying. They're not able to leave. No one is able to pay bail to pay a dollar amount to have them released, and they have the right to come to court every 15 days to have their case heard. There are a number of court dates that happen in between the arraignment and the trial. So there's a pretrial conference in which you're deciding what evidence the DA should turn over, what evidence is needed for trial. You're conferencing. You may have some discussions regarding pleas if it's at that stage. And even prior to a pretrial conference, a defense attorney can make an argument if they read a police report saying there's not enough evidence in this police report, or say probable cause, to show that this young person has committed a crime. There are pretrial hearings in which you're getting evidence, discovery. You may still talk about pleas. There's also what we call non-evidentiary motions, such as you're getting information about, where did the crime occur, who was present, time, place, and manner. There may be evidentiary motions in which you're moving to suppress certain evidence. You're moving to suppress certain actions that occurred during the time of the arrest. And all of these occur prior to the trial. A case you can move to dismiss at any time prior to a trial as well. A young person has the right to have one of two types of trials, which is a bench trial, which is a trial before a judge, or a jury trial, which is a trial before adults who would sit and listen to a case. And I didn't use the word peers because it's not a young person's peers. It's not 12 to 17-year-olds who are sitting in the jury box here in the case. There are adults who are listening and determining whether or not the young person has committed the crime beyond a reasonable doubt. Juvenile courts are separate for a reason, because juveniles are different than adults. And the proceedings, a delinquent case is not a criminal case. So there's not, a juvenile doesn't receive a criminal conviction. They are adjudicated delinquent, found delinquent. One of the things that I found very interesting as I was preparing today, and you're going to see a video very shortly, I wanted to, talk a little bit about race and ethnic disparities, because they are, data has shown that it permeates throughout the juvenile justice system, even in Massachusetts. There's data that shows that Black and Latino children are more likely to be arrested and detained and committed to the Department of Youth Services, while white children are more likely to get diversion. The Citizens for Juvenile Justice, they have a number of studies, and one of their studies shows that while 38% of white children who got arrested, only 38% of white children who were arrested were arraigned on cases in Massachusetts, while 64% of Black youth who were arrested were arraigned. There was also a 2015 study from the Sentencing Project that showed that African-American youth are at least 10 times as likely to be locked up as white youth when compared to the general population. And that children between the ages of 12 and 18, these are important statistics to consider, because children between the ages of 12 to 18, children whose brains are still being developed, they can be arrested, they can be charged in court, they can be removed from their homes and confined in locked facilities. And at times there can be serious consequences for the young person for missing that time with family, missing that time in school. They are educated while they're in the facility, but it is different from going to your schools that are out in the community. This time I think it's a good time to show the video.
Sorry, pull it right up. Have to be in present.
When you walk into a facility, all that you see is a sea of Black and brown bodies.
Racial injustice is evident, within these youth prisons.
It's mostly African-American males. It's obvious.
It's hard to try to argue that it's not a racial justice issue.
You see these two white staff all of a sudden just rushing into the room. All of us just standing there and watching, my friend who was African-American, being beat down by the staff. I'm like, why'd you go and do that? And he's like, what do you care? He's like, at the end of the day, kid, you're only here to pay my paycheck. In that moment, I realized I was just seen as a dollar sign to this man.
I would define structural racism as a hierarchical inequity that is characterized by white supremacy.
If you have any questions about what structural racism looks like, I encourage you to walk into a juvenile prison in America, talk to the Black kids who are in those facilities, and ask them what their experience has been in the juvenile justice system.
When the 13th Amendment abolished slavery, it actually kept an exception for people who were convicted of a criminal offense. And so the criminal justice system and the juvenile justice system became the new vehicle for controlling the lives of people of color.
After the Civil War ended and we saw this influx of African Americans exercising what they deemed as their freedom, immediately we saw institutions go up, these youth prisons be built to house young Black African American males.
Post-Emancipation Proclamation, you know, unfortunately, as a whole, as a country, we thought it was our opportunity to do away with racism. We thought that we'd gotten past that particular issue. And through sharecropping, through Jim Crow, through segregation, the drug epidemic, we find that, you know, society, especially here in the US, we just reinvent that issue.
It's almost like it was meant to be. Like at no point in our history would Black males be completely free.
So Virginia is indeed the heart of the Confederacy. You can walk down on the James River and stand in the very place where Black lives were bought and sold. You can walk the slave trails.
Some states highlight the fact that their institutions have been around for hundreds of years. And that's certainly like a slap in the face for our brown and Black allies. And I think it's disgusting that a state would highlight the fact that their institution has been around so long in the heels of the end of slavery.
The Beaumont facility was built in 1890. And when they began incarcerating young people there, those young people had to work the land, much like slaves.
New Jersey happened to be the last northern state to abolish slavery. The New Jersey Training School for Boys was opened in 1867. It's 2 years after emancipation, after slaves were free. They put a process in place called gradual emancipation, which meant that children who were born by slave mothers had to work as indentured slaves until they were young adults.
In Kansas, we're also the state of Brown versus Board of Education. To be able to go just a few miles from the Brown versus Board of Education school building to the Kansas Juvenile Correctional Complex, our one remaining youth prison, and walking in and seeing the racial disparities in that facility, again, it's just difficult to walk away from that and not feel like we have a special responsibility to fix this and fix this quickly.
Our youth prisons were created at a time when human bondage was legal, a time when whites were willing to see Blacks as less than human. Young people will come into these facilities in leg irons and shackles. There's been incidents of correctional officers actually hog tying. Some facilities use something called a restraint chair. You know, everything that they do, they're being watched and they're being controlled, and they're being deprived of their own agency and their own worth.
When you look at some of the communities that are the highest committing to the juvenile justice system, they are impoverished communities. They are communities that are struggling economically. The school systems are failing, and there is a lack of hope and opportunity in those communities. And it is just a reflection of the way Blacks were treated when they were first brought to this country on slave ships.
And so what we have a system right now, one system of justice for white youth and for, upper middle class youth, and then one system of justice for poor youth and youth of color.
The kids know, they are aware that the color of their skin affects how they're going to be treated. I don't see people who look like me behind those bars. I don't know how you can say it isn't a racial justice issue.
I feel like the movement is ripe. The time is now for this message to get out that this is no longer just a juvenile justice issue, but a racial justice issue.
I see a sea of diverse faces who come to a place because you, like me, know that change, when it happens, it always happens from the ground up in our communities.
My hope is that we can fight for a world where no young person is locked up, where young people have the opportunity to be their full self, where young people have the opportunity to live their destiny and to carry out their dreams. That's my hope.
Now you're going to hear from Migdalia regarding sentencing. So regarding what will happen if a young person pleads out or resolves their case through a plea bargain, or is found delinquent after a trial or guilty after a youthful offender trial.
Thank you, Tinia. I know that video is powerful, and we chose it because we don't think that the words that we can tell you will completely give you that visual or complete perception of what the juvenile justice system looks like now. And the way that we organize our segments, I'm going to talk to you a little bit about sentencing, and I think this video is completely relevant to it, and I'm happy to, we're happy in the Q&A to process the video a bit more and obviously answer your questions about the juvenile justice system and anything you may have heard in the video. Essentially, talking about sentencing in the juvenile court, again, is directly relevant in the sense that, that's the ultimate penalty for the juveniles who are charged with delinquency/crimes. It's kind of interesting that the juvenile court considers the charges or the offenses delinquent, and they try to kind of separate it from what a crime would be. The reality is there's a blur because essentially right now, thankfully, as of only 2 years ago, the jurisdiction has changed in the juvenile court. Well, when we all first started working in the juvenile justice system, up until 2 years ago, 2.5 years ago, 2018, our legislator and our laws were that 7 to 18-year-olds could be charged with crimes and delinquency offenses. And so when we first started this work, Tinia, myself, and I'm sure Eliza, we had 8-year-old clients, 9-year-old, 10-year-old clients charged with delinquency offenses. And any offense in the juvenile court for a juvenile, it could be from shoplifting, from the most minor offense to the most serious offense. Homicides are the only charge that are outside of the juvenile court's jurisdiction and are tried by the Superior Court. But anything else, rape, attempted murder, any shootings, anything involving a gun, any type of weapon, mayhem. So going from the minor disorderly conduct to the most serious charges, for all of them, you can have the most minimal consequence, right? Which would be potentially like what we call like a pretrial probation. It's kind of the best type of probation that you can get, where you can face a few conditions, maybe like go to school every day, like a kid that the court trust, and the ADAs and the defense attorneys negotiate that this kid will do really well as long as they have a little more support. Maybe the kid has to do counseling, maybe just join an after school program, see how well you do, and then your case can be dismissed after a certain amount of probation. So that would be kind of the most lenient type of penalty and sentence, to the maximum, which is a DYS commitment till their 18th birthday. So thankfully, up until 2 years ago, now the age has raised from 7 to 12-year-olds. So now no longer can any child under 12 years old can be prosecuted for a crime. Basically, if there's a behavior issue, it needs to be dealt with in another way. Give the kids the supports they need in the community to get through that. But from 12 to 18 now, on this current jurisdiction, if any 12 to 18-year-old is charged with the crime, including shoplifting or disorderly conduct, any type of minor, like larceny under $250 or now under $1,200, ultimately, the legislature has a statute that if it's their first offense, like minor offense, it's not a felony, they are entitled to get diversion for their first offense. But essentially, like the second offense, they have to be arraigned. And once you get arraigned on a shoplifting or any minor offense, any juvenile can face up to DYS to their 18th birthday in custody. The way it actually works is that DYS has their own kind of like sentencing guidelines. We call it a grid, where if a child is committed until their 18th birthday, the child essentially has to serve a certain amount of time in custody, and then DYS will decide without the court's input at all when they decide to take that kid, release the kid into the community on like what would be similar to parole conditions, but they call it they have their own conditions. And essentially that child is still under the custody of DYS, even if they're released to the community. And any violation, if the child doesn't go to school, the DYS has the absolute right to bring them back into custody. And again, as long as they decide to do that. And they have a procedure for doing that, but essentially the child could be held until their 18th birthday. And I say, I start with that just to let you know, I'm very fortunate and happy that I started working with adults first, because it shocked me when I came into the juvenile court, when I worked with the adults, if adult was charged with a shoplifting and that adult was arrested, let's say on a Sunday night, and they had to spend the night in jail, that Monday morning we would go to court. And for an adult, their first offense, it's a $50 fine for a shoplifting. Like the second offense is like a $150 fine. And the judges would dismiss it on, court costs all the time, or even dismiss it on, hey, you spent a night in jail for this, your case is dismissed. No longer does an adult have to deal with the shoplifting charge. Unfortunately, in the juvenile court, that's not the case. When I started here, it was like, oh, shoplifting, oh, well, we need another continuance. It'll be 2 months out, 3 months out. And when you have a case pending for a juvenile, there's so many reasons for them to then, get tied into the system, because now they're being monitored for school. If they don't go to school, if if they're smoking weed, or if their parents complain about something going on in the house, they can easily be sometimes even charged with a new offense, or just kind of like a hook to get them more court involved with all that constant supervision. And so I find it that one of the unique things about the juvenile court too, when Tinia was saying that it's separate, it's confidential. So it's bittersweet, because yes, it's a good thing that you're keeping a child's information confidential, but at the same time, and this would help protect them for collateral consequences. But at the same time, there's a lot of unfairness and racial injustice that happens that people don't see. People don't see that, most of the kids, even in Massachusetts, are Black and brown. Right now, the population is, most of our clients, I've been in this specific position for 4 years, but I also was a prosecutor some years back. And in my 12 to 13 years of experience now, again, most of the people that actually come to the court are Black and brown. I have had obviously white defendants as well, but it's is predominantly like the Black and Latino communities that are also filling the prisons. One other thing I would quickly say about sentencing in terms of keeping to time, there's a youthful offender statute that allows 14 to 18-year-olds to be treated, basically 14 to 17-year-olds, to be treated as adults. So when we're talking about the difference between delinquency and crimes, when the juveniles commit any offense, which the popular ones right now, possession of firearm, that's it, and armed robberies. So if it's an armed robbery or possession of firearm charge, they're almost very likely to be treated as an adult under the youthful offender statute. That statute allows under 3 specific criteria for someone to be charged as an adult. And what that happens, when that happens, essentially that juvenile faces an adult, is exposed now to the same exact adult sentence. So if the armed robbery, for instance, is a life imprisonment sentence, maximum penalty for adults, that life imprisonment maximum penalty will also apply to a juvenile that has been indicted as a youthful offender and who could be 14 years old with an armed robbery charge facing life imprisonment. Does it happen practically? Like, I think the juvenile court has been great about really trying to treat the juveniles as juveniles and separate from adults. And the DA's office, usually when they indict, what they're looking for is to expose them to DYS until they turn 21, because that's the kind of the minimum penalty that they can get when they get indicted as a youthful offender. They get 3 additional years with the Department of Youth Services. However, when they do indict, there are times where they add on a house of correction or strict probation or give them a suspended like state prison sentence. And depending on the charges, again, if it involves, it's not just a possession of firearm, if it involves discharging the firearm and any potential like attempted murder or assault charges, they could, again, add on that additional adult time. So that's, in the interest of time, that's where I'll stop with sentencing.
Yeah, no, I had to mute the other monitor.
Oh, and I'll introduce Eliza, who's going to be talking about collateral consequences.
Hi, all.
Yeah, there have been maybe like
Sarah, you're
10 new folks that have joined since the panel.
Okay, I think that's my colleague Sarah, who's behind the scenes on several panels. So I didn't realize she was unmuted here. So thank you, first of all, Tinia and Migdalia, so much, and we'll transition on to Eliza.
Hi, so I'm just going to run through a few collateral consequences for juveniles who are charged with crimes. You know, there's obvious consequences of probation and being committed to the Department of Youth Services or sometimes jail. But there's sort of the intangible collateral consequences, right? And I think Tinia kind of touched on some of those, like loss of time with your friends and your family, trauma, you know, the inability to take advantage of some resources in your community, et cetera. But there's also some consequences that are statutorily imposed on kids. And I think the 2 most important ones, or the 2 that sort of come up for us the most, which is where I'll start, are school consequences and housing consequences. So in housing, if a juvenile lives in what's called Section 8 housing, which is for people who get government assistance to pay their rent, for certain charges, you can be evicted from your Section 8 housing. And obviously, if you're under 18 and you're living with your family, sometimes that means that the family has to make a decision where they don't allow you to come home or they all leave. And so I don't think I need to go into all the problems that can create, but that's a really big consequence that can affect you whether or not you end up in jail or DYS or on probation. And then in terms of school, and I think I'll echo what Tinia and Migdalia said about race, this is one of the places where this affects Black and brown kids at a higher rate than white kids. You can, if you're charged with a felony, so accused of committing a crime, not convicted, you can be suspended for the entire time a case is going on. So until you get to trial. And for instance, right now, we're in the middle of a pandemic. The courts have been mostly shut down for this time. That means that a child could have been excluded from school for a year and a half, for 2 years, for however long the case is going on. You're entitled to a hearing, but the principal and the superintendent essentially just have to think that you are a danger to somebody in school, and they kind of have free reign to make that decision, and then they can exclude you. If you are convicted of a felony, then you can be expelled from school, so not allowed to come back at all. There are some requirements for educating kids that are excluded from school, but they are not up to the level of what actually going to school every day is. And then on top of that, certain drug offenses can affect your ability to get financial aid if you go to college after high school. So pretty extensive consequences that can affect you in the really long term. And then just to touch on a couple ones quickly, a couple other ones. There are, well, this is not a small one either, immigration consequences that can affect you. Hopefully these are going to be a little less with this new administration, but for the past 4 years, we have seen ICE officials at courts waiting for children to walk out of court so they can arrest them and take them to an ICE detention facility. And I've had more than one client who has walked out of court and into an ICE person's custody. Driving conditions or driving consequences. Some drug offenses can affect your ability to get your license or to get your permit. Some offenses can make it so you can't go into the military. For juveniles, your record is a little more protected than for adults. So not everybody, like for employment, will have access to it. But some employers that work with vulnerable populations, so with kids, with elders, things like that, will be able to have access to those records. So it may affect your ability to get those types of jobs. Some professional licensing agencies can see your record, so that could affect your ability to get a job. And then for youthful offender convictions, so kids who are indicted and open to adult sentencing, their records are also more available to the public. So there's really a lot that can follow you through life, both because the law says that it can, and just because these things just sort of follow people. So it's not, once the case is closed, you're not done.
First of all, let us, if we can unmute ourselves or virtually give an appreciative round of applause to our three panelists, Tinia Snow, Migdalia Nalls, and Eliza Lockhart Jenks. So thank you so much, the three of you. We are just about at 10:30, and we definitely want time for questions and responses. I saw there was one question already that came up in the chat. Because we have a break planned at 10:30, what I'm going to propose is we can start to answer some questions now, and then take the break. And when we come back, we'll give chance for more reflection and questions from the panelists. And then move into our next activity, so there's time for that, for any questions people have. I wonder if we can, maybe this is the one question we can get to before we do stop to break, and someone asked about a current court case that is going on. Mar-Sophia?
Mar-Sophia. Yeah, so I just wanted either of the panelists' thoughts about the Jordan Tyrell case that just came down this week. So my thoughts were, obviously it's going to affect more Black and brown children, since they are the ones who are being funneled into this system. So for people who are not familiar, basically a judge committed a young person to DYS until their 21st birthday, but they were held there pre-trial. So the judge credited the child with their pre-trial term. And when the Commonwealth appealed it, the SJC said that the judge can't do that because they have to, because DYS has authority to basically assess the youth and their treatment plan. That's the short version. So I just wanted some thoughts.
So I think that's a great question, and I found this decision particularly frustrating because in the past, the SJC has expressed concern over exactly this issue, over children being held pretrial and not being credited that time when they get sentenced. For those that don't know, when an adult is held on bail and then gets sentenced later, the time that they're held while the case is going on is credited toward their ultimate sentence. So if they are held pretrial 6 months and they're sentenced to a year in jail, they only serve 6 more months because they've already been held for 6 months. And juveniles don't get that. Don't get that. And the reasoning for the argument for that is that once they get sentenced to the Department of Youth Services, they're in there for treatment. They're being treated, and you can't predict how long the treatment will take. So, so the pretrial time just doesn't count. They're just sort of sitting there. I agree with you that I think it's super problematic, and I'm not sure what the reasoning was there beyond sort of just accepting this argument of treatment versus jail. But I think it's a really problematic decision, and it's something that a lot of attorneys have been working on for a while to try to get that time credited. And so we're gonna have to figure out a new path forward, I think.
Thank you. So I see some comments from Lou, a question from Lou, and a comment and sharing of some insight from Ohio, from John as well. And so what I'm going to propose, but given the time that we're at, is if we can, the schedule has us taking a break from 10:30 to 11 and then coming back here. So what I propose is if people want to take Zoom break, you can put off, put the screen on, stop sharing your video, et cetera, but stay on this Zoom. You can step away from your laptop or computer and then come back at 11. And again, we'll have a chance to do more questions and answers and comments and reflections. And then we'll move into an activity where we'll do a little debating about this as well.